Welcome to the deep dive. Today, we're really digging into something critical for everyone in healthcare. That's the legal side of wound care, and why getting your documentation absolutely spot on is so essential. We're pulling the key ideas from the chapter Legal Aspects of Wound Care in that really well-regarded text, Wound Care Essentials, Practice Principles.
Yeah, and this isn't just academic. Understanding this stuff is fundamental.
Mm-hmm.
It's about protecting yourself, sure, but it's really about ensuring high-quality patient care.
Exactly. It's foundational.
Mm-hmm.
So we've boiled down this chapter to let's say, the must-know legal principles and documentation points that, well, you probably need every day. Our mission here is just to make these concepts clear and hopefully practical.
And it's timely, too, isn't it? Patients are, well, they're more informed consumers now. They do their homework online.
That's a great point. They come in armed with information.
Right? And maybe more willing to seek legal advice if they feel things didn't go right.
Mm-hmm.
The internet, social media, it's all changed the dynamic.
Definitely. Now, thinking about lawsuits, we often picture, those dramatic TV courtroom showdowns.
Uh-huh.
But the reality of how a medical malpractice case actually starts is usually quite different, isn't it?
Oh, absolutely. Much less dramatic, usually. It typically kicks off when someone feels they've been harmed, maybe by their medical care, and they go talk to an attorney.
Okay, so step one is that initial consultation with a lawyer. What's the lawyer thinking at that point?
Well, the attorney does a kind of preliminary assessment. They're asking themselves, can I handle this type of case?
Right.
Do I have the expertise, the time? Is this potential client credible? Will they make a good witness?
So they're sizing up the situation right from the start.
Exactly. And they're looking at the potential damages.
Mm.
Is the harm significant enough to justify, well, the massive effort and cost of a lawsuit?
Right.
They need to identify who might actually be liable, legally responsible.
Yeah.
And crucially, what's the likelihood they can prove both that liability and the damages? Any obvious problems with the case right off the bat?
So a lot of hurdles, even before deciding to take the case.
A huge amount of initial assessment. And if those boxes get ticked and the client agrees, then they might move forward.
So it's not an immediate jump to filing suit.
Not at all.
Yeah.
Especially in medical malpractice. Before formally filing, attorneys usually conduct a much more intensive investigation.
Okay, what does that involve?
It almost always means getting hold of all the relevant medical records and having them meticulously reviewed, usually by medical experts. They need an expert opinion on whether the care provided actually fell below the accepted standard.
So they bring in medical professionals early on.
Yes, to see if there's really a case there from a medical standpoint. They also need to figure out all the potential defendants. It might be a doctor, a nurse, the hospital itself, maybe multiple parties.
Mm.
And they have to consider jurisdictional issues, basically. Which court is the right place to file a lawsuit? Only after all that, if they believe they have a strong, viable claim, will they actually file the official complaint that starts the lawsuit.
Okay, so it's a very deliberate process. Now, assuming a lawsuit is filed, who are the main players involved?
You've got three key groups. First, the parties. That's the plaintiff, the person initiating the lawsuit claiming they were injured, and the defendant, the person or entity alleged to have caused the injury.
And that defendant could be an individual doctor or nurse or the whole hospital.
Or a clinic or even a corporation, yes. Then you have the judge. The judge acts as the referee overseeing the entire process. They rule on legal questions during the pretrial phase and interpret the law during the trial itself.
Making sure the legal rules are followed.
Precisely. And third, if it goes to trial, you have the jury. This is a panel of citizens who listen to the evidence presented by both sides.
And they decide the outcome?
They decide the facts of the case, what they believe actually happened based on the evidence. And based on those facts and the judge's instructions on the law, they determine liability and, if appropriate, the amount of damages.
Got it. Okay, so the lawsuit is filed. What happens next in that period before a potential trial, the pretrial phase?
Right, the pretrial litigation process. It generally unfolds in a few stages. First up is the complaint and answer.
That sounds like the initial paperwork.
It is. The complaint is the document filed by the plaintiff that formally outlines their claims against the defendant. It explains the alleged harm, why the court has jurisdiction, the legal theories they're relying on, and what damages they're seeking. It's their side of the story, legally speaking.
And the defendant responds.
Yes, the defendant files an answer. This document responds point by point to the allegations in the complaint. They'll admit, deny, or state they lack sufficient information to respond to each specific claim. This exchange really frames the issues in dispute.
Okay, complaint, answer. They've stated their positions. How do they get the facts?
That leads to the next major phase, discovery. This is the formal process where both sides gather evidence and information from each other and potential witnesses.
How do they do that?
Through various tools, they can demand relevant documents, send written questions called interrogatories that must be answered under oath, and very importantly, take depositions.
Depositions. We hear that term a lot. What exactly is that?
A deposition is sworn testimony given by a party or witness outside of court, usually in an attorney's office, with a court reporter transcribing everything.
Under oath, you said.
Yes, under oath. And this is critical. Deposition testimony can be used later in court. If someone changes their story at trial, their deposition testimony can be used to impeach their credibility, basically, to show the jury they said something different before.
So what you say in a deposition really matters.
Absolutely. Discovery also involves identifying expert witnesses each side plans to use and exchanging reports or summaries of their anticipated testimony. The goal is to avoid surprises at trial.
Get all the cards on the table, so to speak.
Pretty much.
Okay, so we have the initial pleadings, then discovery. Is there another pretrial stage?
Yes. There's often significant motion practice. Throughout the lawsuit, especially during discovery, disputes can arise. Maybe one side thinks the other isn't handing over documents they should, or there's a legal argument about whether certain evidence is admissible.
And they ask the judge to decide.
Right. They file a formal request, a motion, asking the court to rule on the dispute or issue an order. The other side gets to respond in writing.
Does the judge just read the papers?
Sometimes. For simpler issues, the judge might rule based solely on the written submissions. But for more complex or significant matters, the judge might schedule a hearing where the lawyers appear in court to argue their positions orally. These motions can sometimes resolve parts of the case or even the entire case before trial.
Okay, so the pretrial phase can be quite involved. What if, after all that, the case still hasn't settled?
Then it proceeds to trial. It's worth remembering that the vast majority of medical malpractice cases actually do settle before reaching trial. But for those that don't, a trial is the next step. And in MedMal, these are almost always jury trials.
What does the trial process itself look like?
It starts with jury selection. Attorneys for both sides question potential jurors, a process called voir dire, trying to select a panel they feel will be fair or perhaps slightly more receptive to their case. Procedures vary quite a bit by jurisdiction.
Trying to get the right people on the jury.
Essentially. Once the jury is seated, the trial proper begins with opening statements. Each lawyer gets to address the jury directly for the first time, outlining what they intend to prove and providing a roadmap for their case.
Setting the scene?
Exactly. Then comes the core of the trial, the presentation of evidence. Because the plaintiff has the burden of proof, they have to prove their case, their attorney goes first.
How do they present evidence?
By calling witnesses to testify, introducing documents like medical records, showing photographs or other exhibits. When a witness testifies for the plaintiff, direct examination, the defendant's attorney gets to question them, cross-examination. There can also be redirect and recross-examination.
A back-and-forth questioning process.
Yes. Once the plaintiff has presented all their evidence and witnesses, they rest their case. Then the defendant's attorney presents their case in the same way, calling witnesses, introducing evidence.
Okay, after all the evidence is in.
The attorneys give their closing statements, or summations. This is their final chance to speak to the jury, summarize the evidence in the light most favorable to their side, and argue why the jury should rule in their favor.
Their last pitch.
Right. Then, the judge reads the jury instructions. This is crucial. The judge explains the relevant laws the jury must apply to the facts they've heard.
Guiding the jury on the legal rules.
Correct. The jury then retires to a private room for deliberations. They discuss the evidence, weigh the testimony, and work towards reaching a unanimous or majority decision, depending on the court rules. This deliberation room is considered sacrosanct, completely private.
And finally,
they reach a verdict. The jury foreperson notifies the court, and the verdict is announced in open court.
Is that always the end of it?
Not necessarily. The losing party often has the right to appeal the verdict to a higher court. They might argue the judge made a legal error during the trial or that the verdict wasn't supported by the evidence. Appeals can add months, even years, to the process.
Wow, it can be a very long road. Okay, let's shift gears slightly. To win a medical malpractice case, what specifically does the plaintiff need to prove? Our source mentions 4 key elements.
That's right, 4 essential elements. And the plaintiff has to prove all 4 by a preponderance of the evidence.
Preponderance of the evidence. What does that mean in practical terms?
It basically means more likely than not. Think of the scales of justice. The plaintiff's evidence for each element just needs to tip the scales slightly in their favor, over 50%. It's a lower standard than beyond a reasonable doubt used in criminal cases.
Okay, more likely than not. What's the first element?
First is duty. The plaintiff has to show that the healthcare provider, the defendant, owed them a duty of care. This usually arises automatically when a provider-patient relationship is formed. The duty is to provide care consistent with the standards of their profession, their training, experience, and relevant facility policies. It's that legal obligation to act reasonably towards the patient.
So once you agree to treat a patient, you have a duty. What's next?
Second is breach of duty. This means the plaintiff must prove the provider failed to meet that duty, that they didn't meet the required standard of care.
How is that standard determined?
It's generally defined as the level of care that a reasonably prudent and skillful healthcare provider with similar training and experience would have provided under similar circumstances. Proving a breach often requires expert testimony from another provider in the same field to explain what the standard was and how the defendant's actions fell short.
So doing something wrong or failing to do something right.
Exactly. It can be an act of commission, doing something wrong, or omission, failing to do something necessary. It's essentially negligence, failing to act reasonably.
Okay, duty, then breach of that duty. What's the third element?
Third is injury causally related to a breach of duty, often just called proximate cause or causation. This is critical. The plaintiff must prove that the defendant's breach of duty was a direct cause of the patient's injury or harm.
A direct link between the mistake and the bad outcome.
Yes, there has to be a connection. Legal tests, like the substantial factor test or the but-for test, are used, meaning but for the provider's negligence, would the injury have occurred? If the answer is no, then causation might be established. For example, if side rails weren't raised despite policy, breach, and the patient fell and broke their hip, injury, the failure to raise the rails could be the proximate cause.
The injury wouldn't have happened without the breach.
That's the idea. The injury needs to be a reasonably foreseeable consequence of the negligent act or omission.
Makes sense. And the fourth element?
The fourth is damages. The plaintiff has to prove they suffered legally recognizable harm or losses as a result of the injury caused by the breach of duty.
What kind of losses count as damages?
It includes economic losses, things you can put a number on like medical expenses, lost wages, future care costs. And it also includes non-economic losses like physical pain, emotional suffering, loss of enjoyment of life. The damage is the harm itself. The damages are the monetary compensation awarded for that harm.
Got it. Duty, breach, causation, damages. All four must be proven, more likely than not.
Correct. If the plaintiff fails to prove even one of these elements, their case fails.
That really underscores the importance of good practice. Now, let's talk about the evidence itself. Our source says the medical record is arguably the single most important piece of evidence in these cases. Why is that?
It's absolutely central. Think about its multiple roles. First, it's a legal document. It's the official record of what happened or what should have happened. Second, it's a vital communication tool for the entire healthcare team.
Right. Everyone relies on it to know the plan and the patient's status.
Exactly. Third, it's the basis for treatment decisions. Clinicians rely on the information in the chart to decide what to do next. And fourth, it's used to evaluate the treatment provided did the patient respond, were adjustments needed.
It serves so many functions, and that famous saying the source mentions, if it wasn't written down, it didn't happen. That sounds harsh, but legally...
Legally, it carries a lot of weight. Incomplete or missing documentation creates huge problems for the defense. If you claim you provided certain care, like turning a patient regularly, but there's no record of it, it becomes incredibly difficult to prove you actually did it, especially months or years later.
Those gaps can be filled in by the opposing side's narrative.
Precisely. The plaintiff's attorney can highlight those gaps and suggest that the required care wasn't given, or that something negative happened during those undocumented periods. It makes it much easier for them to argue negligence.
Beyond the legal risk, you mentioned communication.
Yes, think about a busy hospital unit. Nurses changing shifts, doctors rounding at different times, consultants dropping in. The chart is often the only consistent way everyone stays on the same page. Poor documentation hinders that vital communication.
And evaluating treatment.
If you don't document the patient's response, did the wound improve? Did the pain lessen? Did a side effect occur? It's hard to justify why you continued a certain treatment or why you changed it. Good documentation shows you are monitoring the patient and adjusting care appropriately.
Okay, so meticulous documentation is key. Our source gives some general guidelines. What are the essentials for good charting?
Well, the basics are crucial. Be thorough, include date and time for everything. Be accurate, use correct measurements, terminology, units. Be factual, stick to what you observed, what was done, who said what. Avoid opinions or speculation.
Just the facts.
Just the facts. Be objective. Don't assign blame or criticize colleagues in the chart. Use approved abbreviations only. If it's handwritten, make sure it's legible print if necessary.
Ah, legibility. Still an issue sometimes.
Can be. Make entries contemporaneously as close to the time of the event as possible. Late entries need to be clearly marked as such, following policy. And it should go without saying, be truthful. Never alter or falsify records.
Seems straightforward, but crucial to follow consistently. Now let's zoom in on wound documentation specifically. The source notes this can be detailed and subjective. What challenges does that create legally?
It creates several, because assessing a wound involves interpretation color, amount of exudate, tissue type, and doke. There can be inconsistencies between different clinicians assessing the same wound.
Different people see things differently.
Right, and differences in knowledge or training can contribute. Plus, if the facility lacks clear policies on how to document wounds, using standardized terms, or if wound info gets scattered in different parts of the chart progress notes here, flow sheets there, it gets messy.
Especially with multiple wounds.
Exactly. It becomes very hard to track progress or even identify issues consistently. The American Nurses Association is clear that nurses are expected to assess and document skin integrity issues, including staging pressure injuries.
So how can facilities improve this consistency?
Our source suggests looking at the flow of information. How easily can someone, like an external reviewer or lawyer, follow the story of a wound within the chart? If it's fragmented and hard to piece together, that's a problem. It might require a systems-level look at how documentation is structured, not just telling staff to chart better.
Taking a step back to see the whole picture, what about that very first assessment when a patient comes in?
The admission assessment is critical. Documenting any skin issues present on admission size, location, characteristics is paramount. This establishes the baseline.
Why is that baseline so important legally?
Because it helps determine liability. If a pressure injury is meticulously documented on admission, it's clear it didn't develop during that stay. A detailed description is often more important initially than nailing down the exact diagnosis, especially if the cause isn't immediately obvious. Also, document intervention started and who was notified.
And the source mentions a common misconception about pressure injuries.
Yes, this outdated idea that if a pressure injury appears, say, 24 or 48 hours after admission, it must be facility acquired. That ignores the reality of deep tissue injuries, DTIs.
Explain DTIs briefly.
A DTI is damage to underlying tissue from pressure or shear that might initially look like just a bruise or intact discolored skin. But significant damage has already occurred underneath, and it can rapidly deteriorate into a severe, full-thickness ulcer. The NPI-AP definition is key here. So an injury might have started before admission, but only become visible later.
So that initial skin check needs to be incredibly thorough. What about assessing risk? Should everyone be assessed for pressure injury risk?
Absolutely. Using a validated pressure ulcer risk assessment scale, like the Braden or Norton scale, should be standard practice for all patients on admission.
What does that achieve?
It identifies patients at risk and, crucially, informs the care plan. What specific interventions are needed for this patient based on their risk factors? This assessment is vital for guiding preventative care and also serves as part of the legal defense if an injury develops.
And it's not a one-time thing.
No, definitely not. Risk status can change. Reassessment should happen regularly, and certainly if the patient's condition changes or they move to a different level of care. But, and this is a huge but, the assessment is useless if you don't act on the findings. Documenting someone as high risk means nothing if you don't implement and document the corresponding preventative measures.
The assessment must drive the action. Now, sometimes, despite best efforts, pressure injuries do develop. How does the concept of unavoidable PIs fit in legally?
It's an important concept. Both CMS and NPIAP recognize that some pressure injuries may be unavoidable even with optimal care. This typically occurs in patients who are critically ill, hemodynamically unstable, or have other factors that make prevention impossible or unsafe.
Like if turning them would compromise their breathing or circulation.
Exactly. Or sometimes, sadly, in end-of-life situations where the body's tissues are failing. Patient refusal of care, despite education, can also be a factor. The key is having clear documentation that outlines why the PI was deemed unavoidable, referencing established criteria like those from NPIAP. This is especially vital in high-risk settings like ICUs or long-term care.
Documenting the why behind it. Okay, let's talk about a common documentation element. That turn Q2 hours checkbox. Our source seems critical of it.
Yes, the infamous turn Q2 checkbox gets called out. The issue is that a rigid 2-hour schedule isn't always scientifically supported for every patient or every situation.
Why not?
Well, the type of support surface the patient is on makes a big difference. Modern pressure redistributing mattresses might allow for longer intervals. Plus, the patient's individual risk factors and condition should guide the frequency. A one-size-fits-all checkbox doesn't allow for that individualized approach and can be hard for staff to meet 100% of the time, creating potential charting conflicts.
So what's the alternative?
The recommendation, based on guidelines like the NPI UAP ones, is to base repositioning frequency on individual assessment, considering the support surface and risk level. This means moving away from the simple checkbox to more descriptive documentation about the planned and actual repositioning schedule for that specific patient.
But that requires more detailed charting.
It does. It requires staff training on how to document the individualized plan and the interventions effectively. It's about linking the plan to the assessment, not just ticking a box.
Individualized care reflected in the documentation. Makes sense. What about the moment a pressure injury is first discovered? What needs to be documented right then?
Clear documentation is crucial. Usually the initial note goes in the progress notes. It should include the date and time of discovery, a detailed description, location, size, appearance, stage as possible, immediate actions taken like applying a dressing, offloading pressure, and who was notified? Charge nurse, physician.
And then ongoing assessments.
Ideally, ongoing assessments should be documented consistently in one designated place, a wound care flow sheet, maybe the ADL record, or progress notes, depending on facility policy. Consistency is key so anyone can easily find the latest information.
And identifying the wound correctly is vital too, right? Pressure injury versus something else.
Absolutely. Correct identification drives treatment. Is it really a pressure injury, or could it be an ischemic ulcer, a moisture-associated skin damage issue, something else? This requires objective assessment, looking at the patient's history, maybe discussing it with the team.
What if you're unsure?
Document what you objectively see, the location, the wound characteristics, the surrounding skin. Avoid speculation. Sometimes differentiating requires more data, like vascular studies, to rule out arterial insufficiency if you suspect an ischemic ulcer. Objective data trumps subjective guessing.
Stick to the facts. Who needs to be notified when a new wound appears or worsens? We mentioned the physician.
Yes, timely notification of the primary physician is mandatory. Document when they were notified, their response, any new orders received, and the plan for their assessment or follow-up.
What's the physician's responsibility here?
They need to ensure the wound management meets the standard of care. They might delegate routine care to a wound specialist, but they retain overall responsibility for monitoring progress. And typically, the physician should take the lead in notifying the patient's family.
Okay, let's talk about notifying the patient and family. How should that conversation go?
Promptly and thoroughly. Explain what was found, when, what prevention was already happening, and what's being done now. Be honest, use clear language, avoid jargon or excuses, allow time for questions.
What about managing expectations?
That's important, especially with things like DTIs. Explain that the wound might look worse before it gets better as the full extent of the injury becomes clear. Document these conversations, who you spoke with, what was discussed, their response.
Transparency and documentation. Got it. For ongoing wound documentation, are there tools that help?
Yes, structured forms or electronic templates with drop-downs and checkboxes for specific wound characteristics, size, depth, tissue type, exudate, odor, surrounding skin, can really improve consistency and efficiency. But they shouldn't replace narrative notes entirely. Sometimes you need to describe something unique.
How often should wounds be documented?
It depends. Factors include the wound type, healing phase, care setting, and facility policy. Major guidelines often suggest a full, comprehensive assessment weekly in long-term care, for example, but with daily monitoring and documentation of dressing changes or key observations. Consistency and keeping it in one place are key.
What about wound photography or imaging? Is that helpful legally?
It can be, increasingly so. Think of wound imaging becoming a routine assessment tool, like an X-ray.
Right.
Legally, a series of dated photos showing progress, or lack thereof, over time is generally more valuable than one random picture.
It tells a story.
Exactly. But photos supplement, they don't replace the written record. Each photo needs context, date, time, what it shows. And crucially, you need clear policies and procedures around consent for photography, storage, and access, ideally reviewed by legal counsel.
Consent is key there. The source also stresses collaboration, coordination, and communication, the three C's. How does documenting that help?
It demonstrates teamwork and comprehensive care. Documenting consultations with specialists like WCE nurses, PT, surgeons, noting their recommendations, and showing communication between disciplines paints a picture of coordinated care. If a consultant makes recommendations, document that they were followed up on. This reflects quality practice.
Showing everyone was working together. Now, policies and procedures, PMPs. The source talks about normative versus positive. What's the difference and why does it matter legally?
Okay, so normative PMPs describe realistic standards, what can actually be achieved consistently in your setting. Positive PMPs might describe an ideal, maybe aspirational standard that's harder to meet 100% of the time.
Why is that distinction important?
Because if your PMPs use absolute terms like always, never will, must, or set rigid timeframes, assessment within 1 hour, and you inevitably deviate sometimes due to clinical realities, that deviation can be used against you in a lawsuit. It creates an internal standard you
Yep.
fail to meet.
So overly strict policies can backfire.
They can. It's often better to use guiding language, should, consider, promptly, that allows for professional judgment. That said, if you do deviate from a policy, you need solid clinical reasoning and documentation to explain why the deviation was appropriate for that patient. Policy should guide, not handcuff.
Aim for realistic and flexible policies. The source includes a box on preventative legal care, key vulnerabilities. What are some highlights?
It's a great checklist. Key things include understanding that words matter in policies, strict compliance with prescribing rules, ensuring everyone practices within their scope, especially around assessment and documentation, managing patient expectations through careful communication, having absolutely thorough clinical documentation covering everything from admission skin checks to risk assessments, PI details, EHR use, photo guidelines, staging, understanding preventability classifications, providing ongoing education, and implementing preventative clinical care bundles. Staying current with major guidelines like NPIEP and WCN is also vital.
A lot for institutions to focus on. Okay, last clinical phase, discharge. What are the key legal points for wound care when sending a patient home or to another facility?
The main goal is ensuring continuity of care and adequate resources at the next stop. You need to document the teaching provided to the patient caregiver about wound management, their understanding, teachback is great here, any referrals made, home health, social work, and exactly what supplies or equipment went with it.
And follow-up.
Yes. Document the plan for medical and wound follow-up appointments. Critically, perform a thorough discharge assessment documenting the status of all wounds. Then, you must communicate this detailed wound information clearly to the receiving facility or home health agency. Don't assume the standard discharge summary covers it adequately, especially for nursing needs.
A warm handover is crucial. Okay, let's wrap this up. If you had to summarize the absolute core message about legal aspects and documentation in wound care.
It boils down to this. The patient's chart is far more than just a clinical record. It's a crucial legal document and the primary communication tool. Therefore, complete, accurate, and timely documentation isn't just good practice. It's essential for providing safe, quality care and for mounting a credible legal defense if care is ever questioned.
So documentation protects everyone.
Yes. Ensure it's legible, thorough, professional, factual, correct, accurate, and timely. Consistent charting reflects quality interdisciplinary care, and the systems supporting documentation need to be well-designed and kept up to date.
Excellent points. Thank you. So, a final thought for you, our listener. Wounds are visible. They often cause understandable anxiety for patients and families. Considering this, how can you best navigate those concerns, communicate effectively, and ensure your documentation accurately reflects the often complex reality of care, including those situations where outcomes might be unavoidable despite best efforts? Something to definitely mull over in your practice. We really encourage you to think about your own documentation habits and maybe check out some of the resources mentioned. Thanks for taking this deep dive with us today.